They were still legal, but the opinion was they were not enforceable.
Thank you.
Thank you.
Chair calls on Senator Reiner.
Thank you, Mr. Chair. Good morning.
Good morning.
I sat and listened to the testimony yesterday morning, and I have to say, the testimony I'm hearing today is considerably different. I felt like yesterday their offering testimony that truly had an atmosphere, and I want to congratulate you for coming here and being slow and methodical in your approach to answering the questions. I had a remarkable number of emails overnight after my constituents were reading the blogs and everything that was flowing out there in the media. And so I guess my first question has to do with going back, and I apologize to the rest of the committee. I can't remember which one of my colleagues asked the question about releasing people from their confidentiality clauses. And I believe you said you would be open to doing that. My request is if you're going to do that, if you could put forth some kind of a statement publicly on the website someplace, because the people I've heard from, and they're just, Joe Sixpack and Sally Sixpack out there in rural Iowa, their problem with the whole thing is if people violate the confidentiality clause, it becomes a matter of integrity. So if you're going to open it up, I beg you to publicly put a statement out there so everyone understands that whoever signed the confidentiality clause is released from it. Because right now, people of Iowa believe that those who have violated, it becomes a matter of integrity, questionable integrity, and then everything those people say is subject to question. And I think it's important that everybody is playing by the same rules, because up to this point, I don't really think we have it all. Everybody can play by the same rules. So if you intend to release people from these confidentiality clauses, my request is that you would make a public statement, post it someplace where those of us who get questions can direct our constituents, okay, here's where it says everybody's released. Is that an unreasonable request?
I would make this statement with regard to that. I would be more than willing to release that. I'm not sure what my legal rights are to waive those. So I would need to check with the Attorney General's office, and provided that there's not a legal problem with any of that, I certainly wouldn't have a problem with doing that. Personally.
Yeah, because what I heard yesterday and what I heard today are really...
Excuse me, Senator, I'm sorry to interrupt you. What you have to realize is that if people decide that that's what they want, that confidentiality agreement goes away, and that's not always in the benefit of the employee. So those are things that need to be considered. And those are things that legally I don't know. I'd have to check on that. But if personally, if there's not a legal question, I would not have a problem with it.
Very good, thank you. Really, the assignment of this committee is to seek the truth and get it out there. And so far, we just have, it's like we're putting a puzzle together. But some of the pieces of that puzzle are still missing. And, unless we, as a committee, is about more than 4 people I questioned there. So I think I heard you respond to Representative County that it would be beneficial, not just to the committee, but also for the people of Iowa to open confidentiality agreement and really just total transparency, but redacting, of course, Social Security numbers. And I feel sorry for the guy whose name is John Miller and is a state employee, because there's probably at least a dozen of them. But surely there's a way that those folks who have fairly common names and there can be some protections. But did I understand you to say that, in fact, we would all be better served if this information was out there?
In my opinion, we would all be better served with this.
Thank you, Mr. Chairman.
I'll ask a couple of short questions in the House side of the rotation. One about the so-called blacklist. Director Carroll, the first question I'm going to ask is regarding the oldest settlement agreement on record to the best of our awareness. And because your tenure started more recently, I'm not sure whether you would direct me to Mr. Woodley or Mr. Carlson, but please direct me to your executive that could best answer, to the best we know, let's take care of it. When was the oldest settlement agreement? How far back did this go?
Well, it goes back to 2004, I believe, is the earliest one, which was part of the Branstad Administration. The electronic records are much easier to search than the paper records. We have searched through 45 boxes of settlement agreements from the Branstad Administration and have found, I believe, 5 settlement agreements with confidentiality clauses in them. So it goes back at least that far. We haven't gone back any further. And if you are truly watching out for the taxpayer dollars, I would encourage you not to go back any further. It's a very laborious, time-consuming thing to go through all of those paper documents, but it does go back that far. Oh, sorry, Paul corrected me. He's been going through the boxes. It's 2000 or 2001 is the first one.
Either 2000 or 2001?
Yes.
Yes, that helps. I also appreciate your added comment about the laborious nature of that, because in this very room, when we got to pretty close to the 11 o'clock hour, there were some good amendments being considered that should we go back to 1983 or perhaps the beginning of collective bargaining in 1973, as we look at this issue in the House bill that was passed by committee in this room last night. That's helpful as we give consideration to that. 45 boxes was a laborious task, as you said.
And if I might make a comment, if you do go back that far, frankly, the issue isn't going to change. So if you're interested in solving the issue, I think the issue's on the table, out in the open, and through the Executive Order 85, part of it's been dealt with. And with additional legislation, you can deal with a lot more, but we could go back as far as you want and come up with as many numbers as you want for whoever's administration you would like, but the issue will not change. So I might make that point. Thank you.
It was very helpful to many of us who gave strong consideration to that last night. The issue of the blacklist, as it's referred to, I have really quick questions on that. First, what is the proper way to describe this disqualification of employees? Is it actually a list? What's the proper term for that process?
If employees are terminated, that they can become classified as disqualified from further state employment through, like I said before, 2 ways: by mutual agreement, So through the mediation process or settlement process, an employee can agree that they will be disqualified from further state employment. That's one way. The other way is there are specific criteria within the code that say if an employee that's terminated meet those specific criteria or multiple criteria, they shall be disqualified from further state employment. Like I said, at that point, they don't go on a list. Their employee record simply gets coded as disqualified from further state employment. If they apply for a job with state government, that code tells the hiring agency that they are disqualified and not eligible for state employment. At that point, their application is sent back to them along with the letter, as I said before, with their rights of appeal and the procedure to appeal that decision.
That helps. I'll quit referring to it as a list now that it's very clear. It is not a list, it's a code on that employee's file.
Right, a disqualification code.
The appeal process for that employee in that case, it wasn't a mutual agreement. Please walk me through briefly. I know you're going to share because one of the legislators asked for a copy of that document later. And if you do that, sir, please send it to all members of the House and Senate on the documents to be forwarded.
Sure.
The appeal process from the employee perspective, how does that work? As I received the letter, please just describe for us how they can appeal whether their file is coded in this fashion.
I can't answer that question for you because I don't know the specific steps. I know there's a letter that goes, Human Resources handles that, and I can't answer that specifically. But when the letter comes back to you, I'm sure it'll be very clear and specific as to what those steps are, but I don't know what they are.
Well, my buzzer just went off, so I got to quit. So I'm now calling Chair Hughes.
Thank you. I'm going to go back to your math on saving the state money. Your equation, I believe, is just part of the equation because you start out with, you laid off 7 long-term merit employees, and in their place, you've hired 3. And then you've also entered into contracts with construction management companies that would then fulfill the work that was being done by those 7 people.
Correct.
Could you explain to me, I've been told that the RFP process was a very small RFP process for these construction management companies to come in. Who issued the RFP? Could we get a copy of that? And then what are the names of the companies that you hired to do the work of these 7 employees? How much money have we paid to those companies since these 7 people have lost their positions with the state?
Certainly. The RFP process would have been handled through the procurement enterprise. They would have issued the RFP and made the responses to that. At that point, those responses would have been scored. It's the normal procedure whenever we go out to procure services. They would have been scored, and then a number of those individuals would have been called in for an interview based on their technical scoring and their pricing. And then firms would have been selected after that point. I think there were 6 firms that were selected out of that. I'll try to name all of them. I know Ryan Companies was one of them. J.E. Dunn was one of them. DCI was one of them. The Whites Company was one of them.
Story Construction.
Story Construction was one of them. And there was one more, I think. GTG was the other. So those were the 6 that were originally selected. As far as the cost of their services compared to what we were doing before, again, in the Legislative Services Agency issue review, they show that the cost of using these construction managers was 1.2% less per volume than using state employees. We do on the average about $60 million worth of construction a year. So 1.2% of 60 million was actually a savings of $720,000. That number never showed up in the issue review, but the percentage of cost did. So the actual cost was 1.2% less on volume than it did before we made the change.
So did the Legislative Services Agency go through to see the amount of money that was being spent with each of these contractors?
As I understand it, yes, that was all part of the issue review.
Okay. The confidentiality agreements that were signed by people that were part of the layoff, explain to me the rationale in also requiring people who chose retirement to also sign confidentiality agreements when they took forced retirement. How many forced retirees were requested to sign confidentiality agreements? Who made that decision, and why were we asking forced retirees to sign confidentiality agreements, and where did the language come from?
I don't have the answer to those questions, but we'll certainly get them for you. I'm not involved in that process in Oversight.
So you wouldn't be the person signing off on the confidentiality agreements for the forced retirees as part of, under your tenure?
No. If it had to do with retirement and sick leave and all of that, those are, I don't get involved in those.
Talk to me a little bit about your relationship with the governor's office. It seems like, I know he said he does not like to micromanage. Give me just an idea of what type of communications do you have with the governor? What types of issues does he care about going on in Department of Administrative Services?
Well, one thing I did find out is he cares very greatly about confidentiality clauses and settlement agreements. That was a kind of a one-way communication, frankly, and I found that out very quickly and very definitely. He doesn't micromanage, frankly, and I don't work probably at my best under a micromanaged situation. Like I said, I have 35 years of experience in the construction industry and also in business itself. Construction is a business, as some of you may know. And as a result, he relies on my judgment, I'm assuming other department directors' judgments also, and our abilities and our experience to make the right decisions to improve state government. He expects to know when issues come up that he needs to know about. Typically, if there's an issue that I think he should be aware of, I would communicate with the chief of staff. It's most of my communications with the governor's office. As far as the communication back from the governor's office, it would either be to me through the chief of staff, or sometimes the director of department of management would be the two people that I would normally talk to on communications issues with the office. Yeah.
Chair calls on Representative Butler to be followed by Senator McCoy.
Thank you, Mr. Chairman. Just a couple of quick questions. This blacklist or disqualification agreement, how far does that go back? Does that go back to 2000 or 2001, or help me out?
I know it goes back to 2011, because that's when I sat down in the chair in my office. As far as how much further back it goes than that, I don't know. Mr. Holman stated he thought it was 20 years, but I have no idea. We could probably get that information for you to accurately.
Okay, you, if I understood you right, you're thinking it could go back 20 years.
I don't know. I'm just saying there was a statement in the paper that went back that far. So I would have to find out specifically, and I'd be glad to do that for you.
Okay, do you know offhand what section of law it is that this qualification is?
No.
Okay.
I know it's code, but I'd have to get those sections for you.
Okay. And I'm thinking of a situation, let's say somebody lost their job at a state institution for elder abuse, okay? And they have a disqualification agreement. My question is, if that person would go to another state, does this, and apply for a job in the same type of a facility, et cetera, does that facility have access to our blacklist or disqualification?
No, they do not. That's strictly the state of Iowa disqualification.
So this abuser could go to another state and go right back into the same type of facility that he or she was in here and continue their